Welcome, everyone. Thank you for joining us. Today, we are so excited to have Valerie Grombchevsky with us from AIG. Valerie is the Vice President of Advanced Sales at AIG Life Brokerage. In her role, she is responsible for providing consultative legal and life sales expertise on large case planning and as well as complex insurance strategies. Prior to joining AIG, she was with Wells Fargo's private bank, and she also worked at MetLife in their advanced sales center, and she started her career at Pac Life. Valerie is a graduate of California State University, and she resides in Southern California with her husband and 2 children. She also is a member of the Advanced Practice Center, and we are very excited to have her today. So thank you to Valerie and to AIG. If you have questions for Valerie, which I'm sure you will, please put them in the chat and we will get to those at the end of her presentation. So thank you, Valerie.
Thank you. So what we're going to be talking about today is what everyone should know about estate planning. And I know there's different variations on, some of you may know what we're going to be talking about quite a bit. Some of you, it's a refresher, and for some it may be new. But even if you know estate planning and the basic estate planning, what I'm planning to do is talk a little bit more of the real life piece of it, and some examples and thoughts and conversations about actually presenting it to clients and having those conversations rather than just the technical part of it. Because we can all kind of follow the technical part, but it's also important to know how that actually is going to translate into having those conversations with clients, as well as for yourselves and why it's important. So over the past 2 years, consumers are more likely, in a study from LIMRA, 31% more likely to buy life insurance. And I've always been a believer that life insurance fits into an overall picture. It's not you sell it, it's a solution. So you're looking at, estate planning, maybe business planning, but what are their needs? And then that's where the life insurance fits in. So we've got an increase in people because of what's been going on for the past 2 years of people being interested in life insurance. The other key point when you're talking about estate planning is the study also found that when you're ranking what's important to people, family increased from 49% importance all the way up to 82%. And that's just things that have been going on, through the pandemic, and have made people more acutely aware of, family and the importance and the time that they spend in their planning. So because of those statistics or just change in the way that people are viewing things, I think it's important to look at estate planning, even from the very basic, but maybe think about it differently in how you're presenting it. So the first, though, the agenda, what we're going to be talking about is what happens if you die without a will, the basics of estate planning, some other documents that's important to think about, and who needs a trust and why. So the first is what happens if you die without a will. So if someone dies without a will, it's called intestate. So don't have a will, intestacy. Each state has intestacy laws. Now the idea is the state has come up with a distribution of how they think you would more than likely want your assets to be passed. And I'm going to talk a little bit more detail to kind of highlight that. But that's kind of the thought process, is who would be the natural heirs if you would have done some planning. So even though you haven't done a plan, it's kind of the no planning plan. You've actually have something, depending on the state that you're living in, that's how it's going to be distributed out. The problem of that arrangement is that it's statutory. So you can't venture out of that if you don't have any directions. So that's important to know. So there's a uniform probate code. I'm kind of going through it quickly because I'm going to talk about it. But it depends on who you have around you, meaning that, are you married? Do you have a surviving spouse? Do you have children from that marriage? Do you have children from a previous marriage? Do you have surviving parents, or do you have other, which would be like brothers and sisters, nieces and nephews in a different generation or a different line? So depending on those answers, the Uniform Probate Code splits up your assets in different ways. And some states have adopted pretty much the Uniform Probate Code, or they have minor tweaks. So this kind of gives you an idea of what you may find if you die intestate, or if your clients die intestate. So for example, you have a surviving spouse, or you do not have a surviving spouse. I'm sorry, you do have a surviving spouse, no children from a previous marriage, no parents, then the surviving spouse receives 100%. If you have a surviving spouse and you have children of that marriage and no one else, then the surviving spouse still receives 100% of your estate. Next, it kind of gets a little bit dicey of whether or not it's more likely than not that this is the way that you would want it, is if you have a surviving spouse, no children of that marriage, but you have children from a previous marriage. The assumption is that you would want something to be left to those children. So the statutory is that the spouse receives 150,000 plus half of the remaining estate. That means that the children from your previous marriage receive that other half. That may or may not be what you or your clients want. And as I had mentioned, there's no way around it. So for example, there was a client that I had that they were not married, but they had been together for over 20 years. So for all intents and purposes, for their emotional state, they were kind of husband and wife. But in the state of California, they were not married. There's no common law marriage. So when he had passed away, he had no will, and he would have wanted everything to go to the surviving partner. However, he didn't have anything in place. So it had to go through probate. He had a surviving brother. The brother even wanted everything to go to his brother's partner, but he couldn't do that. So even if he disclaimed, if you're looking at the chart, it wouldn't go to her. At no point will his assets go to her. So the only way that they could potentially remedy it is it would go to the brother through probate proceedings. And then he would have to actually use some of his exemption and gift her those assets. Because even if he disclaimed it, the next natural would be his children. Again, still not what they wanted. And that's getting more common than not. So it may not even be like a contentious situation. I think sometimes we have a habit of going towards, problems or contentious family situations. But even if everyone gets along, if there's no plan, it's going to go through whatever the probate laws are of that state that they are a resident of. So it still makes it more difficult. So what is estate planning? That's the important question. And as I had mentioned, family is more important to people. It's more of a heightened awareness. So when we're talking about estate planning, it's really the emotional part of it, to me, is maximizing what you or your clients want to have happen with their estate or their assets. It doesn't have to be someone who is a high net worth, ultra high net worth. It's anyone who has some assets, who wants to pass on those assets to their loved ones, next generation, brother and sister, mom, dad, whomever it may be. It's whatever's important to those clients or you. And I keep saying you because I want you guys to also think about not only for your clients, but if you guys haven't done your own estate planning, I also want you to think about it for yourselves as well. It's just as important, not just our clients, but also for us. So it's how do we want those assets passed down? what's important to us? What do we want to see happen to the next generations or for our heirs? So it really is about fulfilling that legacy more so than, I would say, necessarily the tax planning or trying to do all, finagling all the different strategies that we can do. It's really focusing on what are the desires and wishes and how do we fulfill that. So over the years, I've been in this business for almost 3 decades. I've gotten a lot of, excuses on why people don't create an estate plan. So we're going to talk about each of these, and I'm sure you have your own as well. One that I get a lot is their attorney or their accountant is taking care of it. Either that or, oh, I have an attorney, I have an accountant. If it was important, they would bring that up to me. I'll say that they've gotten better. Accountants and attorneys have gotten better about bringing up the topic, gotten a little bit better about marketing and reaching out and trying to get business and trying to update their clients. But I'd say overall, there's still a lot of lacking from both accountants and attorneys in the sense of being proactive and taking care of it and talking to their clients about these, estate planning or their needs. They might bring it up, but they're not going to actually often delve into, what are your goals? What are your wishes? What do you want to happen? So that is almost, to me, a non-starter, because what they'll say is, oh, they're taking care of it, or if it was important, they'd bring it up. So my retort is, well, if they haven't brought it up, then you need to have that conversation. I already have a will. Do you receive this a lot? And that's great. But the question there is it still valid? Does it still do what they want it to do? And in some jurisdictions, is that all they have? So maybe they did a will, but they didn't do a trust because they didn't think it was necessary. In some jurisdictions, a will and a trust is pretty standard for estate planning. In other jurisdictions, a few jurisdictions, a will suffices. But the question is, well, how long ago did they do it? We need to take a look, see if there's anything that's changed in their family, any kind of huge family, like a birth, a marriage, deaths. What's changed? Anything changed? It's time to have that review for a will. Similarly, we'll get, I already have a trust, everything's in order. Same kind of retort is great. Just want to make sure it's what you want, that your wishes are still the same, that there hasn't been any major changes within the family that would change your wishes that you wrote in the will. The big mistake that I see for revocable trusts is that people think that it acts like an irrevocable trust, that they won't pay estate taxes or that there's tax planning in there. The thing to remember is that the tax planning comes after they die. If it's a revocable trust, there is no asset protection. There is no estate tax savings at that point in time. It's only once it becomes an irrevocable trust that you can potentially have some of those protections. This is a mistake that I hear often, that clients think that just because they may have like an AB or a credit shelter trust drafted within there after they die, they're under the mistaken belief that they won't have to pay estate taxes due to that planning. So that's something to clarify. Everything that they own is joint. For a lot of people, this is good, but the thing for jointly held, and it will transfer when one of them passes. Well, what happens if both pass? If there's a common disaster or a simultaneous death, then that's when you have a problem, because who's going to step in? Now, I'm not saying that jointly held assets are not good, beneficial, easy for some people, but it's not necessarily a cure-all. So it's reviewing your overall estate plan, making sure that all your wishes, clients' wishes, are still in order. And well, what happens if both die? That should be a conversation to have as well. I love this one. And in fact, I advise my parents, if they can do it, great. spend it before you die. It's a great in theory, and it's a great kind of catchphrase and fun, but the reality is you can't. You don't know when you're going to die. So the worst thing to do is kind of spend, and then not have money when you're older and you need it. So that really is just one of those, I'd say, flippant remarks that people make that in reality, really difficult to happen. This I do hear quite a bit is, who cares? Kids have more than they deserve. This I've found is more often a result of either the kids aren't quite doing what the parents want them to do, meaning maybe they're going down a different path, or they're spendthrifts and parents are concerned about them. It generally isn't actually that statement that they have more than they deserve. Because then the conversation is, well, what would you like them to do? What would you like to incentivize them to do? So the thing to think about with a lot of clients, and maybe some of you who are listening, we forget that there's so many different options, and our clients don't necessarily know that they're options. They just kind of think, oh, well, I don't want my kid to get all of my assets. Well, they can incentivize. Maybe it's important to get degrees. Maybe it's important to do charitable work, or maybe it's, important to have like a spendthrift trust where you give out a little bit and match for their W-2s or something like that. So it's pretty much whatever they can come up with that's important to them. An attorney can draft that in. So that particular comment, I think, really opens the door to having conversations and having meaningful conversations with the clients as far as what they really want to accomplish. And often I'd say it really isn't that kind of flippant remark of, they have more than they deserve, they don't need anything else. It's just that they don't want them to have absolute control. So that opens the door for quite a bit of conversation, I would say. This is actually one of my favorites, is how would the IRS know they don't know my true wealth? For 30 years, I've been telling people, you don't want your clients to be that one. You don't want them to be the test case. And they will find out. They'll find out one way or another of the wealth. And it is very difficult to hide, and you do not want to be on that end. So why not plan for it? And you can plan pretty effectively. So I would not ever count on that. Heard they're eliminating state taxes. I hear that every once in a while, which I'm sure you guys do, depending on what's going on in Washington, D.C. But that's unlikely to happen. And again, it's just planning for whatever the law is today and making sure that you have flexibility and review it on a pretty often basis, maybe 3 to 5 years, just to make sure nothing's changed. But the key would be flexibility in case there is actually a time that there's no estate taxes, or when you die, there's no estate taxes. So again, flexibility can be drafted into those documents to account for that. I'm too young to worry about that. I think that's more of a mistake that we may make, that clients may be too young, no reason to have the conversation. We're going to talk a little bit more about different ancillary documents that are important, that I think it's important for everybody to have pretty much at the age of 18. So you're not really too young to think about estate planning, and your clients aren't too young to worry about it. And like I had mentioned earlier, this is not just about ultra high net worth clients. This is anyone who has assets that they want to pass on to heirs or any loved ones. So who can benefit from estate planning? Basically, through that list that I talked about, it's really anyone. So it's anyone with assets, anyone with a family, subject to estate tax, charitably inclined. Really anyone can benefit from estate planning, or at least at the minimum having that conversation. And I think that's our role, to bring up the conversation with clients. So how are you going to begin? I am a true believer in partnership and working together with different financial advisors. You've got the attorney who's going to advise on legal matters is going to do the drafting. They're going to do, you know, all the estate planning that you need or the clients would need. They're going to handle all the legal work. You've got a CPA or a tax professional who's necessary if you're going to be doing any kind of gifting, or if any kind of, you know, potential asset transfers or selling assets, estate planning, like the taxation. If you need something more complex, it's important to have someone, a tax professional or a CPA involved in that partnership. The other is a financial professional. They're great. We're great for the, you know, looking at cash flow, liquidity, estate equalization, having those conversations with the clients. I'm going to throw out one more statistic to you, that there's also another research that was done regarding consumers and who they feel they receive the best information from. So 82% of consumers find that they receive the most helpful, most complete information from their financial professional, from their financial advisors. My thinking behind that is that financial advisors, we have the time to have those conversations with our clients. Often they're seeing their financial professional way more often than they're seeing their estate planning attorney. And then more often than they're seeing their CPA or their tax professional. CPA, maybe it's once a year and it's sending them out all the forms that they need to have their taxes prepared, but that's it. No super, you know, in-depth conversations, talking about their needs, talking about family. And I know I'm generalizing, but that is generally the case with those two professions, with the CPAs and the attorneys. With financial advisors, you have more in-depth conversations about the family, their needs, and what's going on in their lives, and often are touching them more often. So that's why I believe that they feel that they get the most helpful advice. 82%, that's a huge statistic, from financial professionals, because we can have those conversations more in depth, spend the time. You're not, you know, charging them hourly for those. And then they can also just ask questions about options. And I'm not saying, you know, practice law or practice tax. It's just having the conversations. And then when something needs to be done, you partner with an estate planning attorney, or you partner with a CPA to actually get those professionals to weigh in and give legal advice and tax advice. So going to the documents, what exactly is a will? It's just a legal document that's defined by state law. And what I mean by that is each state has its requirements that are necessary to have a valid will. So maybe it's 2 witnesses have to sign, and maybe it's a notary. So it just depends on whatever state you're in. Clients just have to follow those rules, but it's just a legal document. And in that document, the person who's going to handle any kind of, you know, signing the last tax return, collecting of assets, potentially paying estate tax, that person is called an executor, and they're named in a will. In the will, you can also designate beneficiaries, say how your assets are going to be distributed. And important, if you have minor children, you're going to designate who is going to be the guardian of both their estate and their person. So that doesn't have to be the same person. So the person is going to be the one who takes care of them, as, you know, where they live, those types of decisions for them. And then financial is all the financial matters. So that's what's important there. In the will, when you're saying, you know, how the assets are distributed, it could be distributed to a trust. And we'll talk about that a little bit more in a couple minutes. But that's basically what a will is. And what is probate? So probate happens regardless if you have a will or if you die intestate. If you die intestate, the court handles everything over that probate process, and you are under the statutory rules of probate code. And like I had mentioned, even if you have a will, you're still going to go through probate. The will has to be admitted to the court, Basically, they validate it. And then any property that is subject to probate is going to be inventoried, appraised. And, if you have assets in another state, say you have a home, California, a home in Texas, you're going to be subject to 2 probates, an ancillary probate. And then from that, once all those assets are collected, any kind of final debts are going to be paid, and then anything remaining is going to be distributed out per the terms of the will. Now, the difference is depending on what's in probate, how fast you can get through probate, or how slow it is. So that the idea in some jurisdictions is to get as much out of probate as possible and potentially have it transfer either, and we'll talk about this in a second, but either by trust or by other means so that you're avoiding probate. So probate property is just property that's going to be passed under your will. Non-probate property is property that passes outside of the will. So 6 types of non-probate assets. Any kind of assets that are like contract, so 401k, IRA, life insurance, where you name a beneficiary. That is not going to be a probate asset. Any kind of accounts, usually you're going to see this in bank accounts, payable on death or transfer on death accounts, where similar features like a beneficiary designation, that if someone passes and you have a pay on death, then whoever you've named is going to be the beneficiary of that account. Any assets that you own jointly as joint tenants with right of survivorship, similar, is going to pass to that joint survivor. Depending on this jurisdiction, you may have a tenancy by the entirety, where it will just go to your spouse when you pass. Revocable trusts are not, anything in a revocable trust is not probate assets. And then any assets that you have a life estate, because a life estate ends when you pass away. So we're going to talk about a couple examples. We've got Monica and Chandler, who are recently married. Once they got married, they created new bank accounts, jointly held. However, Chandler had his old checking account and didn't change the ownership on that. So what happens is, since he forgot to change his ownership, it was a pay on death to his mom. So if something happens to Chandler, his mother is going to likely receive the checking account, not Monica. So the point of this hypothetical example goes back to the beginning when I was saying any kind of large family events, birth, death, marriage, it's important to review your documents as well as all beneficiary designations. Now, having said that, it is possible that Chandler would want his mom to be the beneficiary of this account. If so, that's fine. But if he doesn't, you need to have that review to make sure that everything is in order to follow the wishes of your client. Hypothetical number 2 is that we've got Lewis, who's recently divorced, and he has 1 adult child and a 401k that he regularly had contributed to. He failed to change the beneficiary of his 401k after the divorce, and it's currently listed as his ex-spouse. If something happens to Lewis, then his previous spouse would likely to have the 401k rather than his adult child. Now, I know some of you are thinking this if you're in community property states. There's other issues, if you got divorced or split it, that's not really the point, or it's kind of beyond the scope. But for our example purposes, is that if you have a beneficiary designation, so we're going to assume that all of those divorce things were worked out, the only thing he didn't do was change that beneficiary. So everything is, when the divorce was finalized, this is his 401k, and he forgot to change the beneficiary. It is likely that she will then receive the balance of that 401k instead of his adult son. So again, the point is just going through everything, all beneficiary designations, all accounts, in addition to the estate planning documents. So other important documents that everyone should look at or consider. First is a living will. It's a legal document where you set out what you would want to happen if you had to have medical treatment. So if something happens to you, this just lays out, do you want extraordinary measures? Do you want life-sustaining measures, and to what degree? When might you want that cut off? So all of those kind of issues or concerns that you may have, if you can't make those decisions, this tells someone, well, this is what I want to happen for my medical needs. It could either be general or specific, it could be general for whatever the ailments may be, or it could be specific to a certain condition or procedure. So if you're going into the hospital, you may want to have something very specific and narrow in scope, or you can have something broad. Another document in conjunction is a healthcare power of attorney. Now, there are some jurisdictions that tie this together, so you only have one document. The healthcare power of attorney is a legal document where you name someone who is going to make those healthcare decisions for you. So with a living will, you say like what you want to happen. In the healthcare power of attorney, that's where you're going to name that person who is going to follow those wishes. And like I mentioned, in some jurisdictions, there will be only one document where you name someone, as well as list out all the things that you want to happen as far as medical procedures, or want or don't want to happen as far as medical procedures are concerned with. The comment that I want to make here that I would say is more personal, just to think about and to have in your mind when you're having these conversations with clients. Very simple to kind of explain, like I just did, as far as what the healthcare power of attorney is, naming someone. But in practice, it's more emotional than that. Is having the conversation about what really would you want to happen? What's important to you? And the other thing that I would caution or kind of highlight for everyone is to really think about who you're naming as the agent for you. Who is going to step in and make those decisions for you? Sometimes we fall into the pattern of, of course, I don't want to say of course, but more often than not, you have your spouse, if you are married, and your spouse is going to make that decision. But then who's next? Sometimes people fall into okay, well, I'm going to have my adult child, or I'm going to have 3 of my children. So the thing to think about on these types of documents, it's pretty simple, but then it can be complex in practice. Meaning, say you do have 3 children. The practical matter is, and it's a personal decision, so I'm not saying one's right or one's wrong, but the practical matter is you will have to have 3 people agreeing on whatever that decision is. And sometimes you might have to have something done quickly. So thinking about the natural progression of these documents, of who you've named, who's going to make those decisions, doesn't make the most sense. Again, like I said, I'm not saying right or wrong. Maybe 3 is perfect for you. What I'm saying is it does involve more conversation of what is the next step. So if we do name these 3, what's going to happen? Is there a tiebreaker? You have to think forward about, so these actually work in a more efficient manner. That's the idea of having these documents, is to be efficient. The other piece of that, though, is who is going to follow your wishes? And I'm going to tell you, on a personal level, it becomes very difficult. So you have to, for example, I'm the youngest. However, my father had named me as the agent because he didn't feel my sibling would necessarily follow through with his wishes, as far as pulling the plug and making some of those hard decisions, which was very important to my father, but could be very difficult on my sibling. So aligning your wishes and desires with whoever you're naming as agent, as well as letting that person know, I'd say is important. So there's way more to just naming somebody. It's having those actual discussions about what people are going to do, just to make sure that your wishes or the client's wishes are going to be carried through. This is relatively new, but HIPAA is not new. But I've been seeing in the past decade more HIPAA releases. The reason is a lot of the older documents do not have adequate HIPAA releases for doctors. The doctors want to be protected by giving your medical information to whomever you've named as agent. So it's important to have a HIPAA release. Some of the documents will have it and will be sufficient, but if you have older documents, they may not have the protections for the doctors, and the doctors will not just hand over medical or documents to the agent. So this just helps the agent or whomever you've named have access to your medical information, which sometimes, they need it for the two doctors saying that you're incapacitated, or maybe it's necessary for them to make a decision of whether or not they need to step in. So this release allows them to have access. The other point here, though, is it doesn't necessarily only have to be that agent. It could be maybe you chose one child to be the agent because of all the reasons I said earlier, but you would like your other kids to be able to weigh in or know what's going on with your health matters. So the HIPAA release can be broader, meaning that you can name multiple people, and then they can all have access to your medical records to kind of protect or oversee the agent that you've named. That's just a thought, that it doesn't have to be just that one that you've named. It can be, but it doesn't have to be. Another document would be the power of attorney. And that's, again, just a legal document where you designate who is going to handle your financial affairs for you if you are unable. This can be general or broad authority, and it could be taking effect immediately or upon incapacity. Again, there's no right or wrong, but it is a personal decision that should be made. Some people want that added protection, that they want two doctors to say that they're incapacitated, and then somebody will step in. If you're incapacitated, that's generally, I don't want to say easy, but not a difficult thing to get two doctors to, sign off and say, yes, you're incapacitated, can't handle financial matters. Or it can be immediately, where that person could step in for you, where it may make it easy, where I've seen it more often, more recently, is with the increase of Alzheimer's, where you may have a loved one who isn't quite ready to give up control, but having an immediate control allows a person or the agent to kind of step in and maybe start paying bills or making sure things are taken care of without fully having someone named incapacitated. So again, it is completely up to the person who is creating that, who they want to name, what they're comfortable with, but there are options, is my point with that. The other thing I want to mention here with the power of attorney healthcare directives, as I had mentioned in the very first, 10 reasons why people don't do estate planning. On the I'm too young, this is something that I always have been bringing up now with clients who have adult children, 18 adults going off to college, where I think we as parents still think that we're able to make decisions for them, but they're adults. So if something were to happen to them, maybe they got in an accident or got sick, and they needed someone to make healthcare decisions for them, or they needed someone to step in to pay bills on their bank accounts. If they don't have these documents, we as parents aren't necessarily first in line. Or if you're potentially divorced and you have, mom and dad that are divorced, who's going to step in and act on behalf of that child? So a suggestion is, when you do have your kids going off to college or 18 years old, is looking at having these documents for them, is having adult children name someone for their healthcare decisions, as well as their financial decisions, if something were to happen to them. So they don't really have a estate most of the time, but these documents are still helpful to help in case something happens or there's a need for medical decisions or finance. So who needs a trust and why? Really, anyone could use a trust. It just depends on what their needs are. And depending on the complexity, you can have some, there's a variation in the price or the cost. If you need something super simple, you probably don't need a high-powered attorney or top law firm that specializes in very complex estate planning. Might need someone just who does wills and trusts. So it could be more economical. So it depends on what their needs are. If they want to do estate tax planning, trusts are generally the best vehicle for that. To avoid probate, in some jurisdictions, probate's a long process, maybe 18, 24 months or more. In some jurisdictions, it could be a quick process. So that's just going to depend on what their needs are and where they're at. If they want to have some sort of control over what they leave, their legacy to their next generation or their heirs, and also asset protection. And that comes in when it's an irrevocable trust, not a revocable trust. But that may be something that they're considering, or mom and dad or grandma and grandpa are considering for their children and grandchildren, is maybe that they want to provide some more of that control, potentially asset protection in the future. So trust is just simply an arrangement where you have a trustee who manages all of the assets. The trustee can be an individual, and it could be a professional individual, and it could also be a corporate or a trust company can step in and act as the trustee. Depending on what your needs are and what your desires are, that's going to dictate who you name as a trustee. You can also name a series of individuals, and then potentially at the end, which, in the beginning, Carla had mentioned, I worked at a bank. You can have at the end maybe a corporate trustee in case all of the individual trustees that were named can't act, or you've created maybe a dynasty or a generation skipping trust. You have a corporate at the end who can, at least step in there. So the benefits, as we've mentioned throughout the presentation, of a trust is it avoids probate. Generally, it's just faster access to all the funds because you have a trustee. And then if that trustee passes, then the other trustee steps in. So there's not that probate or that time wait that you have to wait. So it's a little bit quicker access to those funds. You have greater control of the wealth or whatever assets are in that trust because you can dictate, depending on the options or whatever was drafted into the trust. That provides more of that protection and the control. And once you have the irrevocable trust, you can have some asset protection. You also have privacy because probate is a public process, where a trust, it's not public. Everything's held within the trust. The only people who have access to the trust document itself would be beneficiaries, where they can have access and they can read what their rights are under that trust, but it's not open to the public. So some common types of trusts that we've been talking about mostly is the living trust, where you also have to make sure that all of the assets that you want titled in the trust are actually titled in the trust. So homes need to be retitled into the name of the trust. Bank accounts, other accounts that you have would be named in the trust. You can also have beneficiary designations as, the trust, or even secondary. So for example, when we had talked about, life insurance or IRAs or 401ks, most of the time on a 401k IRA, you're going to have your survivor spouse. But if you don't, or you want it to go into a trust, that could be a contingent if you have, minor beneficiary children. So those are options for those, jointly held assets if you have something as a contingent. It also works with a pour-over will. So when we talked about the will, is it distributes your assets. Once it goes through, probate, gathers all the types of assets that you have, inventory, appraisal, and then payment of debts and distribution. Well, that distribution could be to your revocable trust. It's called a pour-over trust. So that way, all of your assets go into the trust, and it's going to be distributed the way that you want. So the goal would be that you put as minimal amount of assets into the will. So a lot of times it's just kind of, I would say, like a safety net. So anything that you haven't retitled or anything that's kind of left out of those accounts that you maybe accidentally left out of a non-probate situation and it becomes probate, that goes through probate and then will just go into your trust and then be distributed out per the trust terms. Also, irrevocable trusts. So in life insurance, we're very familiar with irrevocable trusts or ILITs. The key thing with, I want to point out with irrevocable trusts is the irrevocable nature is what really kind of keeps it out of your estate. As long as you don't have certain provisions or rights that you've retained in the irrevocable trust, you can keep it outside of your estate. That's why we most often see it if you're looking at life insurance, you would see an ILIT. But the key thing that I want to say there is it's really just an irrevocable trust. And then you can have different assets that are held into that irrevocable trust. Sometimes it's life insurance, and that's where you get the ILIT, but sometimes it's other assets, business holdings, securities, and it's just simply an irrevocable trust. You have different provisions within that trust and different assets. Along that, it could also be drafted for any children with special needs. We will also see that sometimes with irrevocable life insurance trusts, that there'll be language for a child with special needs, just in case, and they'll fund it with life insurance, but that'll supplement that child's needs and for their life expectancy, basically. So I'm going to summarize. We talked about what happens if you don't have a will, what's estate planning, some of the documents, and who needs a trust and why. So the main goal, I would say, of what I'm talking about and why it's important, going back to what we had talked about in the very beginning, some of those statistics. Right now, it's very important for consumers, clients, about family. It's just an increased awareness. Not that family was never important. I would say it's just an increased awareness of how important family has been over these last 2 years. Also, there is an increased desire to have these conversations. There's a realization of mortality. So there is a willingness and an openness to have these conversations. So it is, kind of the right time to, if you have clients that have been hesitant, just to open it up and find out, where they're at, what their questions are, and how you can help guide them. That's why I think all of this is important, is just kind of the timing. And I just am a believer that the estate planning is really important for everyone. At the very, very minimum is to have that conversation. So we've got about 9 minutes or so. I'm going to open it up and turn it back to Carla for any questions that it might have popped up.
Yeah, great content, Valerie. Where did you get that stat on the 82% of the people trust their financial professional over their CPAs and attorneys?
I believe that was a LIMRA study as well.
That's great. You mentioned reviewing the policy and reviewing everybody's documents and making sure we're aligned. How often do you think that review should take place, or that conversation?
I would say at least every 3 years.
Okay.
However, anytime that there's any type of change, any type of family change. So like I mentioned, birth, death, marriage, change in tax law, any of those things, it could be sooner. But at very minimum, I would say 3 years.
Awesome. And thank you. You just added something to my college planning process by making sure I have all of those. When you said that, I've got a 17-year-old that will be 18 next year and is very excited about it, by the way. And kind of now I'm freaked out. So I now do a little bit more planning than I thought. So, well, thank you so much for being here. Thank you for the wealth of information. And I don't think we have any other questions. I'll give people one more chance. Questions, put them in the chat if you have them. And if not, we'll just say thank you and we'll see you at our next NAFA event.
Sounds great.
Thank you, Valerie.